AJE, there's Metro, there's DC Housing, U.S. Marshals, U.S. Park Police, and now with the federal takeover, we got the DEA, we've got the FBI, and other federal agencies, National Guard and whatnot. They're doing joint, they're riding around together, they're walking around together, and so that's a unique situation here in DC. It was already unique, and now it's even more unique. We can keep going through some of these slides. All right, here we go now. I just want to get a little bit of audience participation here. So I'm going to ask you to give me a thumbs up or a thumbs down. All right, so let's learn some law. We're going to learn some Fourth Amendment. Okay, so what is the Fourth Amendment? Right? Some of you may remember this from school and whatnot. So it's a lot of words, but it's the right of the people to be secure in their persons, their houses, their papers, and effects. Now, I'm going to stop right there. Houses, papers, and effects. That was language from back in the 1700s.
Right.
What's the biggest thing? What's the biggest thing that we have to not want to be searched? Our cell phone, right? Our cell phone has so much more than our house, so much more than our papers. This is everything to us, right? And they're taking our cell phones left and right out on the streets. So it's the right against unreasonable searches and seizures, and no warrants shall issue but upon probable cause. There has to be some probable cause to get a search warrant, and that has to be by oath or affirmation. It has to be sworn out. And it has to be particular. It has to describe the places to be searched. With respect to the cell phone, there was a big case in DC. It was my case that went on appeal, and it was overturned because the police just started searching everything in my client's cell phone instead of keeping it limited to what might pertain to that exact investigation. So that deals with the particularity part of this Fourth Amendment. And you have to, and also that you have to describe the places to be searched, or the things to be searched, or the data to be searched.
Right.
Okay? So I'm just going to go through that a little bit, because that's a lot. We'll go on to the next slide here. Decent Court of Appeals, and I am so proud of our office's appellate unit.
Yep.
It's unbelievable. It's something like a 40% reversal rate that our office is able to get in terms of reversing convictions. And one area that I constantly see excellent decisions is in the area of the Fourth Amendment. All right, so we're going to talk a little bit about what searches are. What does reasonable mean in the Fourth Amendment? The classic one, of course, is if you've got a search warrant. There's other times that they can search when they've got probable cause without a search warrant. Another big one, and this is one of the things I want to talk to you about tonight, we can't make it easy. We can't make it easy for them. So many people, unfortunately, allow the police to search them. They give consent. The police a lot of times asks the person, do you mind if I search you? Do you mind if I search your car? Do you mind if we just look through that little bag there in the back seat?
Nope.
And a lot of people, they're afraid, right? They don't know what to do. And they're also afraid that if they say no, they'll look guilty. So, but we've got to be steadfast. We cannot give consent to the police to search. All right? Yes.
Hypothetically,
Yeah.
let's say my car don't have tinted windows. However, the police can look in my glass, through my glass, and they see maybe a switchblade on my seat. That gives them probable cause because it's a contraband and they will be able to get into my car.
That's right. So the question was if they can see things through the windows of the car and they see things that appear to be illegal. That is the next thing. It's an amazing thing that you teed up.
Yeah.
Plain view, okay?
Yep.
If they're interacting with us and they see something in plain view, if they see a weapon sticking out of my pocket, if they see drugs coming out of my pocket, if it's a vehicle thing and they see things in my car, that's why so often in these car stops, there are so many cops there and one person's talking to the driver or the passenger, other people are there looking in.
Yep.
They're looking everywhere that they can possibly see because they know that if something's in plain view, if it is a valid car stop, they're going to be able to get that.
Yep.
A search incident to arrest, if it's a lawful arrest, they can search you, okay? And it's also known as an inventory search. The idea there is they have to account for all of your stuff because let's say you had $1,000 and they didn't make a notation of it, you know, then there's problems. They can be sued, you know, for theft and this and that.
Right.
But of course, they're also hoping that they're going to find illegal things.
Right.
And then emergency circumstances is sort of a vast area of, you know, like let's say somebody's wounded and they're bleeding and they go into their home and the police officer says, I needed to go in there to assist them. Or let's say a house was burning and that's an emergency situation. Or if they feel that drugs could be flushed down the toilet, and it goes on and on. Those are ways that they can comport with the Fourth Amendment even without a warrant.
And what about marijuana? Because if they smell marijuana, and if it's questionable as far as how much marijuana you have on you, that just them smelling it alone gives them probable cause to want to search.
Okay, question here about marijuana, and I've got a couple slides on marijuana just in terms of kind of what the laws are and stuff like that.
Yeah.
But marijuana is a big, big way that the police are messing with people, right? Because marijuana up to 2 ounces is legal in the district, right? But you can't smoke marijuana. It is prohibitive to smoke marijuana in public. But you know, so many people do because it's just one place you can kind of not bother people and smoke your marijuana. So you know, it allows the police to approach you, and then you know, oftentimes it's not like they're approaching you because they want to arrest you for smoking in public. They're approaching you because it gives them an excuse to be able to engage with you and start asking you questions. And then, you know, the police oftentimes, right, they claim you're acting nervous. They claim you're sweating. They claim that you're fidgeting or that you're turning your body or what they call blading, that they claim they can see the contours of a gun or that you're trying to, you know, shield it. And then it goes on from there, and then sometimes people, you know, they get really nervous. They might run away, and it just kind of goes on from there. So it's very important with respect to marijuana to know that you could be messed with by the police if you are smoking it in public, if you're smoking it in your car. So I did I answer your question?
You did.
Pretty much, okay. So let's keep that in mind. Okay, we can go on. She had a good question about consent, all right? And I had mentioned that so many people give consent. There are no consequences to not giving consent. There is no law saying that we must give consent. There won't be an additional criminal charge for saying, I do not permit you to search, okay? There are no penalties for that. There's no fines. There's no possible, you know, a violation or an infraction or a ticket or a misdemeanor. None of that, all right? Because now oftentimes, right, they're wearing their body cam footage, right? So that's going to be on the body cam. And more now people in the community are filming. So the person saying, I do not give you permission to search me. I do not give you permission to search my car. I do not give you permission to search my book bag. Most of the time, that's going to be on film.
They turn them off.
Sometimes they do turn them off, and that's why it's important for the community to film also. And while I'm on that topic, people have the right to use their cell phones to record encounters, okay? The only thing you have to be careful about is giving enough distance.
Yeah.
Because the cops are gonna say, stand back. And as long as you stand, and I'm not aware of a set distance, but let's say it's about 10 feet or so, I think you're on solid ground, and if anything, they'll tell you to stand back a little bit further, okay? So you're not interfering. You can't interfere because you could be charged with interfering with an arrest. Filming is lawful and legal, all right? So in the old days, when nobody was filming anything, the cops sometimes would lie and say the person gave me permission to search. And then it was the cop's word against your clients. And unfortunately, throughout the history of this country, judges believe the cops more than people. Right? That has changed a little bit, and it depends with who the judge is. But I think one of the good things about body cam footage is that we see people saying you don't have permission to search. We can keep going. So the most common type of search is the stop and frisk situation, right? We all know about the stop and frisk, like getting shaken down or frisked. And the Fourth Amendment says the police can only do that if they suspect someone is involved in criminal activity and they suspect the person has a weapon. So if they suspect you of the classic case that came down in the 60s was they claimed somebody was like looking in a business, kind of casing it to do a burglary. And ultimately the Supreme Court said it's okay to approach that person and perform, while I'm investigating, to perform a protective pat down, okay, only on the outside of the clothing. They can't go into the pockets.
Right.
They're just supposed to just pat down. So
And it's a proper
if they're
way
feeling
to
a cell
search.
phone, they know that's not a gun. If they feel a wallet, that's not a gun. They can't go in there, right? Now it gets complicated if they're patting you down for weapons and they feel like rocks that they think are crack cocaine or something like that. There's a lot of litigation about that. There's, they want to claim in the same way of plain view, seeing something in a car, plain feel. But we challenge that. We say no, that doesn't fly.
It's also a proper way to search. They don't supposed to use their digits. They're supposed to use the back of their hands and go down, and they don't supposed to touch with their hands. So it's a proper groping.
That's right. So to perform a pat frisk, they are supposed to be trained, and it should be in their general orders at the police department how to use their hands, and so that they're not groping with their fingers.
Right.
All right. So here we go. We can go on to the next.
Before you leave stop and frisk, can you talk a little bit about the pat down and the what's in your pocket? Can you tell me what's in your pocket? Can you show me what's in your pocket? Can you talk a little bit about that part?
All right. So Maria has a question in terms of just kind of expanding what a typical encounter would be, right? So they're approaching you. This is a detention. They are detaining you. You're not free to leave, right? My advice, and the Know Your Rights advice, is that when the police are interacting with us, in the earliest possible moment, you want to be asking them, am I free to leave? Okay, because if they say yes, then you walk away calmly and get the hell out of there. If they say no, now you're in a detention scenario under the Fourth Amendment of the U.S. Constitution, and they have to have reasonable and articulable suspicion for detaining you. They can't just detain you on a suspicion because you're a particular race, or you're a particular gender, or you're a particular age, or you look nervous, or it's a quote-unquote high crime area. This is what I'm saying, how the DC Court of Appeals has issued some really good opinions. One even says, quote-unquote high crime area plus flight, actually running away from the police, is not enough to justify a detention. Okay, so the police are coming up to you. They're trying to talk to you. You don't have to talk to them. You can say right away, after you've clarified that you're not free to leave, then you can say right away, I choose to remain silent. I also don't consent to any searches, all right? So then when they're trying to engage with you, oh, you seem a little nervous. What's in your pocket? Show me what's in your pocket. Will you just empty your pockets? you don't obey that stuff, right? You're not getting in a fight with them. You're not mouthing off. You're not, you're trying to stay calm. I know it's not easy, but you're being very calm if you can, and you're asserting your rights. Now, I brought some materials. There's certain cards that people can actually put in their wallet, and you could, when you're in an encounter like that, one option is simply to hand that card to the police officer. And that's an assertion of your various rights. I'm remaining silent. I don't consent to a search. Are you arresting me? Am I free to leave? Okay, so these are the things that I want to touch upon.
If they detain you without reading your Mirandas, then they basically they infringed on your rights. Like, they supposed to read your Miranda.
Okay, that's a great question. What's your name?
Amy.
Amy's got another excellent question, and the question is, and I hear this a lot from clients and parents, well, they didn't read me my rights, or they didn't read my child his or her rights. When that comes into play, okay, that the only time that comes into play in terms of what we can get out of that, how we can use that to our advantage when they are not providing you with your Miranda rights, right? Your right to remain silent, your right to have an attorney that you can speak to. The only way that comes into play is if they've actually taken a statement from you, all right? You have to be in quote-unquote custody, something similar to an arrest where you're not free to leave, and you have to they have to be asking you questions. Okay, that's the interrogation part, right? You got to be in custody, and you got to be getting interrogated. And then if they're using things that you answer against you in court, and you were never provided with your Miranda rights, now you might be able to get it suppressed. You might be able to get your statement thrown out of court.
But isn't that hard to prove? They said if you say you didn't read it and then say yes I did, now it's a whole.
Well, again, that comes a lot of times. It's on camera.
If they don't turn it off.
But some of the more serious cases where you're taken to the precinct and you're put in a room and then a detective comes, like for the felonies, those are all recorded.
No, I'm saying, like, let's say I go outside right now, and they stop me, and they are trying to put me in the police car to take me away. Right. Before I get into the police car, and I'm being detained, they're supposed to read at that point, right?
All right, so I do want to correct that, Amy, because they don't have to read you your right to remain silent and your right to have a lawyer, also commonly referred to as the Miranda rights. They don't actually have to read those to you. And if they don't, there's no sanction. It's not like we can sue the police for it or get some sort of damages, right? Because if they never ask you a question when you're in custody, they don't have to provide you with your rights to remain silent because they're not asking you anything.
Right.
All right. And choose to be silent and not answer questions. You can. You don't have to show documents. You don't have to open your door just like in a non-immigration type of encounter. Remember, if someone comes to your door, your question is, do you have a warrant signed by a judge? And if they do, ask them to slide it under the door, or if you've got a glass portion of your door, to hold it up so you can see it. Don't just take their word that they've got the warrant. And same kind of thing. You're going to be asked if you're arrested or detained. Now, the thing is, though, about the immigration context, right, is that the very difficult thing here is that if you don't give your name, if you don't give any documents, you could be just, as we've seen so many times now in the U.S., you're basically kidnapped, you're disappeared, and you're put in the system somewhere. You might be sent to a detention center halfway across the country, and so that's the calculus that you have to make if you're in that situation, to avoid being detained and possibly even sent to some other country, right? Where who knows when you can get out of a jail or a prison in another country. Our country too, but it's even maybe harder in another country. So
Yeah.
you may want to give your name. You may want to give your green card or your naturalization certificate or your social security number, okay? So that's a caveat in terms of, you know, Immigration and Customs Enforcement approaching you or some other immigration agent or official. You may make the decision to cooperate more than you would with a Metropolitan Police Department officer, okay?
But these
And
officers
never
are not
show
giving-
false documents or provide false information.
But these officers are not giving their information, like no ID, nothing.
No,
so
I know.
we're
No, that's the thing in terms of badge, name, and number, and it being visible. MPD, there is a requirement that their badge is displayed,
Yeah.
that their officer ID number is displayed. We have the right to ask for the name and ask for their badge number. But what we're finding, of course, is like these ICE agents and, you know, maybe some of the other federal law enforcement agents that are mixing in now in DC, they're not displaying their information. We can ask for their name and badge number, but I know in the ICE context, they even have masks on.
Yeah,
These
they're covering
people.
their faces.
So you know, it's a serious problem. You definitely want to stay calm, even if the police are not. You want to always, if you're a student, you want to keep and use your student smart trip as a form of identification. And it's, again, it is your right, and oftentimes it's the smartest thing to do is to say, I do not wish to talk. I want a lawyer. I don't consent to any search. And throughout the encounter, you're asking, am I free to leave? Now, let me give you one quick example. If you're just walking down the street and the police are on some sort of foot patrol or something, and they come up to you and they just start walking, and they're trying to talk to you. They're, oh, nice day, yeah, oh man, what a day this is. Yeah, so how's things going with you? Good, you know. And they're just trying to talk to you like that. You don't have to talk to them, and you don't even have to stay next to them. I mean, that's just a random encounter where they're just, who knows what they're doing. They might just be being friendly, or they might be kind of fishing, all right? So that's a situation where they have no suspicion at all. They're clearly not trying to detain you, but they're trying to engage with you. And that's another, it's like, when it's clear that you're free to leave, definitely feel free to do that, you know? You don't have to talk to the police, even when it seems friendly and just kind of random. And then I've got some hypotheticals and stuff like that, but maybe I just take questions now, if there's any remaining questions. Yeah.
I was just wondering, is there someone, do you want to sum this up with the parent?
I can kind of summarize it quickly because one of my colleagues who's in the juvenile rights division of our office put this together, but she was just kind of trying to educate about, you know, what do schools, or should schools be notifying parents when there's interactions with the police?
they don't.
They don't, right? No, they don't. And, so now in the community, apparently, and I haven't heard of this really happening in practice, but apparently maybe there's a general order on it. I think that's where my colleague got this from, the police general orders that they are supposed to follow. So in the community, there's supposed to be a protocol that the MPD shall contact parents to inform them of the youth's status and give them an opportunity to come to their location, and notify parents immediately when they're arrested. I did juvenile representation for a year in DC, and I don't recall them doing that. I mean, yeah.
It's so jacked up in current time we're going through now. He was apprehended for 5. We got the court. I wanted him held. This lawyers forfeit him to get in community. So now the community has him, but he's just running circles around the community placement where he is.
Oh yeah.
And they don't notify me of nothing. I always find out everything at the last minute. Judges don't let me speak.
How old is he?
It's like it feels illegal to be a parent of these kids now.
All right, so yeah, there's a point being made from one parent that she's not being informed of court dates in the family court for the juvenile proceedings, and feels very ill-informed of the process. And then in school too, because one of the questions I was wondering was, if the police come into a school and they want to talk to a child, does the school allow that? And do they have to notify the parents? And apparently the parents don't have to be notified, and the school does allow for interviews.
But that's,
I mean, with some exceptions. I mean, what this says is that if there's a crime of violence that happens inside the school, then the police are allowed to investigate that and interview the person. For something that happened outside of the school, the police should not be arresting a kid inside the school unless there's some sort of exigent circumstances or those emergency circumstances. So this is, it can be confusing, and again, this isn't my area of expertise, but we just wanted to kind of touch upon this subject as well. Is there a time limit? And the example is, like, let's say you get arrested, you get taken to the precinct, you get put in a room. How many hours can go by that they can detain you? If you're arrested, they can hold you before they take you to central booking and all of that. I mean, I've had cases where guys have been in that room for 6, 7, 8, 9, 10 hours. And they're allowed to get away with that because they claim they're still investigating. But you know, there's a lot of tactics, of course, right? Because people get worn down, they get tired, there might be all kinds of physical ailments going on, and they're hoping somebody who's not willing to speak to them maybe will change their mind. So, but there is no hard and fast rule. Now, let's say your attorney wants to try to suppress the statement you made in that interrogation room. The different factors are, have you been touched in any way? Has there been psychological coercion? You know, have they been yelling at you, raising their voice? Have there been multiple police officers interrogating you? All the things that would create a coercive environment where maybe you are not speaking the truth anymore.
Right.
You just want this experience to end, right? So when you're filing that motion, if they kept you in that room for hour after hour, maybe overnight and everything, you're going to put that in your motion.
Yeah.
But it's not a hard and fast rule that they have to release you after a certain number of hours.
wow.
Or process you further.
Okay. All right, y'all. So I'm leaving Potomac Gardens. Very, very informative meeting with Mothers Outreach and Advocates for Justice and Education. I'm an advocate for both programs, and just tapping in with the tenants and people in the neighborhood, and just trying to share resources and get feedback and try to spread awareness. So it was cool.